So today we'll talk about the Fourth Amendment. The framers were adamant that a man's home is his castle. So how is the castle protected by law? The framers said, the right of the people to be secure in their persons, houses, wherever their houses are, papers, and effects against unreasonable, and this is the key, unreasonable searches and seizures shall not be violated. And no warrant, and this is something that comes out of the British system, having a warrant, having something issued by a higher authority that gives the state permission to do what they're going to do, shall issue but upon probable cause, supported by oath or affirmation. And if you've ever seen the cop shows and the cop goes to the judge or the DA goes to the judge and they say, I swear that we've got probable cause to do this, and the judge sort of goes, well, okay, I guess so, and they stamp it and sign it, and the warrant's been issued. Particularly describing, and this is strange, one of those technicalities of the Fourth Amendment, the place to be searched and the persons or things to be seized. So for example, say the police had probable cause to believe that I'm a bank robber, and they believe that the evidence of my bank robbery activities are in my basement. And so they get a warrant to come search my house and find the stuff in the basement. Well, what if I put it in my car? Or what if I put it in the garage? And some very narrow-minded district attorney or police officer says, yeah, it's in the basement because we know it's there, and the judge signs off and it's set and you're ready to go, and they don't find it. And some cop is out having a smoke break by the garage and the door swings open and there's all the evidence. Maybe it gets thrown out. And maybe it gets thrown out because on Fourth Amendment grounds, they didn't describe particularly the places to be searched or the things to be seized. In this case, it would have been the places to be searched. The state needs to play by the rules. And part of the rules is you just don't get free rein to go search anything. And there should be some punishment for that. Here's where the punishment occurred. It was in a case called Mapp versus Ohio. Mapp, M-A-P-P, versus Ohio, 1960. Here's what happened. Police officer enters Mr. Mapp's apartment searching for contraband because he knew that Mr. Mapp had contraband. Upon a search of the premises, they found the contraband, but Mr. Mapp says, and argues, his lawyer says, they didn't have any probable cause to come search my apartment. And so, how did they find this if they shouldn't have been there in the first place? And the court agreed and essentially said, yeah, we agree. They didn't have the right to be there, but how do we get across to them not to continue to do that and violate your Fourth Amendment rights? And what the court came up with was something called the exclusionary rule. And essentially what that says is, if the police enter and gather some evidence that they didn't have a right to gather, a judge can exclude that evidence from consideration in court proceedings, in the criminal proceedings. And as we all know, no evidence, no crime. And so cases get thrown out because the court said, you don't get to violate the person's civil liberties that way. They can have some security in their person, papers, houses, effects that says the state has to provide something that's compelling that says we can come search and seize. Now here's the irony. Since 1960, there have been elements in the law enforcement community, in the criminal justice community, who have been taking cases to the Supreme Court that have been chipping away bit by bit at the exclusionary rule, to the point now it's literally a coin toss on whether something will be excluded that was unjustly seized by the state. One of the other interesting things comes around seizing things civilly. Now, the state has this idea that if you commit a crime, we can seize your property as part of the penalty for you having committed the crime. So, say I'm a narcotics trafficker and I have a $5 million home and a 50-foot yacht and 15 cars and all kinds of bank accounts and all the things that go with being a drug trafficker. And I do something stupid and get caught in a hand-to-hand on a, 500-kilo deal. I'm clearly a trafficker. So the DEA is going to come clink the handcuffs on me, and they're going to drag me in front of a judge, and the judge is going to say, how do you plead? And I'm going to say, oh, but Your Honor, I'm not guilty. Don't believe that I was caught with the evidence. And we're going to have a trial. The state will put on their case. I'm going to be convicted. I'm going to be sent to prison. I'm going to be fined. And I'm going to have whatever the state can prove that I got from the proceeds of that activity, that is going to be seized by the state. The state has proven that these are ill-gotten gains. And so it's sort of reasonable that we could have criminal asset forfeiture. Asset forfeiture in our jurisprudential system has been around since about the 1880s. Now we've moved into civil asset forfeiture, which is much more dangerous. Cut.